Hi everyone, welcome to the video on property law. Bit of a shift in the course this term over previous terms. The lawyers that teach the course are always trying to make sure that the material that we cover is important in two respects. Number one, we want it to be the material that business people need in the real world. And number two, we want to make sure that our program is transferable to the CA program. You get credit for it if you want to become an accountant. So we're going to emphasize property law more this term than we have in the past, but that doesn't mean more work for you, because now that we're emphasizing property law, we are not going to do insurance. Insurance law will be transferred into the BADM 307 Law 2 course. We also cover a bit of this material when we get into the contract assignment review, and we won't duplicate. I'll be able to go through it quicker there, and so we're not actually adding very much to the course. In the past, out of Chapter 9 of the textbook, we've covered intellectual property law. Well, that's property, and so we'll do that here, and then you won't have to see that video. And as a matter of fact, I'll probably drop it from the video links page. Okay, slide 1 just is a cartoon which sort of shows you what property law is all about. It's dealing with who owns the property. You know, do you own the airspace? What do you own under the ground? What can neighbors do and not do? And then we get into personal property, which is the ownership of things like a computer, and we'll talk about that as well. On slide 2, it sort of summarizes the whole chapter. And hey, maybe we finish this slide and we won't do the rest. Just kidding. Property is defined as everything that is subject to ownership, which means real property, personal property, that sort of thing. When we use the word title with respect to property, it means ownership of. Now, title has numerous meanings, you know, title of a book and things like that. But with respect to this chapter, title means the ownership of a thing. So property can be broken down into two main categories: real property and personal property. Okay, real property is land, buildings, and things permanently affixed thereto. So obviously a house is permanently affixed to the ground. Oh no, it can be removed. Yeah, but if it's done substantial damage in removing it, then it's considered to be part of the land. The trees on property can be removed, and we seem to be in a real rush to get rid of all the trees on the planet because, you know, what good are they? Anyway, if they're removed, there's stumps and slash. So there's substantial damage done, and ergo it's considered to be part of the real property. Inside a house, if you have a lamp fixture attached to the ceiling, then if the lamp fixture can be taken off and you only have a couple of wires hanging down and a new lamp fixture can be put on, then that lamp fixture is probably going to be considered personal property and not attached to the land. But in an office building, when you have the lights fixtures built into the ceiling, and removing them would have big gaping holes in the ceiling and hanging wires and things like that, then obviously that would be considered part of the property. A furnace is generally built in the sense that it's attached to the ducts going throughout your house, and it would probably be considered real property. Okay, so that's real property. Personal property breaks down into two categories. The first is tangible personal property, and this is computers and cars and sailboats and tables and chairs, and they're things that have value for what they are, okay, as opposed to what they represent. So what are they? Well, a computer is something that I can do my work on. A chair is valuable because I can sit on it. So pretty obviously, that's how you figure out those things. Intangible personal property gets a little more confusing. These are things that represent value. Gosh, I don't think I've got any coins on me. Not a cent. Isn't that ridiculous? Okay, if I had a $5 bill, I can possess it. I can hold it. It feels, you know, real, but it's not real. But it's intangible. Well, no, it's tangible. I can feel it. No, it's intangible because it's just a piece of paper that's worth a tenth of a cent, maybe. but it represents $5 of buying power. So a toonie, it's a metal that I can hold. It's hard, but it represents wealth. That the toonie is worth 1/10 of a cent, the metal, okay? But it represents my ability to buy 2 donuts with it. So what else? We have contracts. They're 12 pages long, but pages are worth next to nothing. But the contract might be worth $600,000 being paid to me for product that I'm selling, that sort of thing. So it represents wealth. A check. Okay, a check is a piece of paper, and a check for $10,000 is worth 1/10 of a cent. No, it's my ability to take it to a bank and have the bank give me $10,000 for it. So it represents wealth. Now, when we get into trademarks, copyright, industrial designs, and patents, some authors say, oh, this is a third category. There's real property, personal property, and intellectual property. But when you stop and really think about it, a trademark is a mark that can be shown on a piece of paper, but it represents the goodwill in your business. And I can't possess that trademark. I can't hold it. It's not valuable for what it is. Hey, it's a piece of paper with my trademark on it. So it's not valuable for what it is. It's valuable for what it represents. Same thing about a patent. The patent is your ability to build a prototype of something that is going to be sold to a lot of people, but you file a patent to get a 20-year monopoly on the sale of that item. So it's not the item. The patent itself is intellectual property. It's your idea put down on paper, and as long as it has utility, novelty, and ingenuity, then you can get a patent on it. So it's again intangible property. Copyright. I wrote a book. It's the textbook for the course. It's a bunch of paper, but what it represents is my legal expertise put on paper. So I get a copyright on it. Well, that copyright, again, you can't possess it. It's it represents my ability to make money on it, or in this case, the publisher, because they now have copyright in it. And then the last category is industrial designs, and obviously an industrial design is just a filing that you do with the shape of a product, and that shape is valuable to you, but you can't hold the industrial design. You may be able to make the product and sell it later, and then that would fall into a tangible property. But the industrial design itself has got to be intangible. Okay, it's not a separate category. It's nice to talk about it separately because it's a different kind of area of law, but it's the same thing. All right, on slide 3, there's a Latin phrase, and this phrase has caused conniptions throughout our legal history. That phrase translates to "whomever owns the land shall own the earth to its center and up to the heavens." And obviously this is from ye olde English times, I think something back like the 1500. A legal scholar brought it to England from his Latin studies in Italy and started teaching it, but it wasn't a legal doctrine. And then some very clever lawyers, when they were arguing about property, used it in court, and then the courts began to struggle with what exactly this means. I mean, after all, Yuri Gagarin, the first man in space, a cosmonaut from the Soviet Union, flew around the earth, and he said, "I see no God, I see no heaven," and so obviously if there is a God or heaven, it's farther away. And then hell is at the center of the earth. Well, obviously if there's a hell, it's not there, but that's the way they thought back then. And so the phrase eventually became known as, at common law, that you have rights to the surface and everything under the land and above it to heaven. And then they even decided that they were going to restrict that. My slide number 4 shows somebody standing on the earth, and it shows, his owning everything up to heaven and down to the center of the earth. And then slide number 5 shows somebody on the continent of Africa and the Middle East that owns some land. And then the next slide is just a joke. It's if the law of gravity got repealed, what would happen? Well, you wouldn't want to own the land on the side because you would fall. Just a joke. More importantly, over the years, the law has been refined so that you don't own the airspace above you. You get to use the airspace above your property to a reasonable height that you can actually do something with. Okay, so a satellite flies through the airspace. Trespass! No, it can't be, because you can't use that. However, if a plane goes through your airspace, then the question becomes, is there a law passed that says the planes can fly above a certain height through your property because it's good for society as a whole, or are they down too low? Okay, and I'm trying to write a chapter for my textbook to replace the insurance chapter, and in that I talk about cases where a plane flew through the airspace of someone and said, hey, you don't own it. And the court said, no, they don't own it, but they could use it, and so your interference is considered to be a trespass. Under the property, down to the center of the earth, well, if you could drill down to the molten core to heat your house once, then you'd own the property to the center of the earth. But we now know that we can only physically go down so far, despite what you see in some of the Hollywood movies. But you can only go down so far, and so that's the property below your surface that you own. Okay, and then along come governments like the NDP government a number of years ago, who decided that people who own the land shouldn't own the minerals and wealth underneath it. That should belong to all the people. And I somewhat disagree with that. If you have purchased the land, then you're entitled to own everything underneath it. But they said, no, that's no good. We'll take it away, and it'll be for the good of everyone. This is excluding Indigenous people's lands, because that's ruled by a different set of laws. But in the province, the NDP now owns the wealth under the land, and they can assign the Prandra something or other to take stuff out. We'll get to it anyway. They can assign the right for somebody else to come onto your property and drill for oil or drill for natural gas or take out minerals or gravel. They have to compensate you for it. Okay, but they are entitled to come on, and they have to repair any damage that they do. Now, this isn't going to happen in North Vancouver or Richmond or something like that, because obviously it's controlled by a different set of laws, and there's no way they're going to interfere with people in the city. This is mostly leased mineral properties in northern BC that we're worried about. Okay, so now we're looking at land as opposed to tables and chairs and industrial designs and patents. Okay, so we're looking at real property. And the courts have carved up real property into two categories: estates in time, and this is the kind of a term, of course, that could be on part A of the exam, and then interests less than estates. Okay, so let's look at estates in time first of all. It's divided into two categories. Okay, the first is a freehold estate, and the second is a leasehold estate. On to slide 9. Freehold estates are interests in land of an indeterminate length of time. That means this is when you own a residence or an office building, or just a vacant land for investment, you get what's called a fee simple interest. An interest in land closest to the complete ownership. Okay, if it isn't complete ownership, who completely owns it? The Crown does. So technically, The Queen of England owns all the property in Canada. She has delegated it to the nation, which means our governments own the land. Okay? That allows the governments to expropriate properties to put in an ALRT out to the airport or a new bridge that's going to cause some people to have to move. They have to compensate you for expropriation, but they are entitled to because they own the land. We are just really occupying it. Fee simple, and if you get a certificate of ownership from the Land Title Office, it says on there that you own a fee simple. Life estates, the best way to talk about this is to use my dad as an example. My father and mother bought a piece of property and they built a house on Gabriel Island with a view of the water, and it was really nice. My mother passed away before they could move over, but my father eventually moved over, and he met another woman, and they got married, and she began to do improvements to the property. So my father did a will which said there's myself and my two sisters, and he did a will saying, hey, I'm the male of the family, so I get the property, and my two sisters get everything else that's divided up. I could not convince him to do it otherwise, and I knew that was going to upset my two sisters. So I told my two sisters that when my father passed away, I would sell the property and we would divide it up equally amongst us. So, but anyway, after a while, he got married to this lovely lady, and she began to make improvements to the property. She put on extensions so they could have a dining room and a nice deck and things like that, and she paid for it. So I went to my father and I said, okay, Dad, it's time to think about what we do about Sally, which was her name. And he said, what do you mean? And I said, well, when you pass away, I get everything and she gets nothing, and she put money into the property. And so he said, oh, I never thought of that. And so what we did was we redid the will so that I would get the property, but I would have to pay her something for the increased value of the property due to her investment. And if my father passed away, and it was likely he would pass away before her because of the age difference, she wasn't a young woman, but he was older than her. Anyway, if he passed away, I could come on and say, hey, Sally, get out. I'll give you some money, but get out. And I said that wouldn't be fair either. And so we gave her a life estate, which means that my father owned the property, but she had a life estate, and she could live there after my father passed away for as long as she wanted. Okay? If she decided to move out, got tired of my dad and left, then she would be vacating the property when my father was alive. And so the reversionary interest, meaning the interest that she had, would revert to my father. Okay? If she was living in the house and my father passed away and she stayed there and then left or passed away herself, then that would be considered a remainder interest because it cannot revert back to my father because my father's dead. So it would the remainder would come to me, the person that's getting the property under the will. So that's slide 9. On slide 10, it talks about joint tenancy and tenancy in common. And my wife and I, for example, own this really nice house that I'm in right now. And we own it as joint tenants, which means that should she pass away, the property would automatically transfer into my name. It would not go through her estate. That's really valuable from a tax point of view because if the property, let's say it's worth $1 million, if we didn't own it as joint tenants, then her half interest in the property would go into her estate, and the estate, it isn't a tax because the government doesn't call it a tax, otherwise it would be double taxation and against the law. They call it an estate fee. So you'd have to apply for probate, and when you do that, it used to be, and I'm not sure if it still is, 14% of the value of the property gets paid to the government. Hey, windfall gain. They can do that without angering people generally because If my kids inherited the $1 million property and 14 grand went to the government, they would go, hey, like chump change, man, we get the rest, and the windfall gain. They'd be happy that we're dead. At least, well, I hope they wouldn't be. But anyway, you know what I mean. So if it does not go through the estate, so she passes away and it comes to me, I get it automatically, does not go through her estate, the government doesn't get anything. That means now if I pass away, instead of the government getting $7,000 for her half interest for doing absolutely nothing, they'd get $14,000 from my estate. So eventually what we will do is we will put our children on title with us, and we will own, between my wife and I and the kids, joint tenancy, but between the kids it will be owned tenants in common, so that if we pass away and it gets transferred to my two children, and they have husbands and families, if one of them passed away, then that value would go to the other person, and that wouldn't be fair to their estates. So they own in tenants in common, but the four of us own as joint tenants. Wow, confusing, eh? Anyway, the right of survivorship is what we're talking about. When somebody passes away, who gets what? If I owned a piece of property with a business associate of mine, I would not want it in joint tenancy, okay? Because I don't want to pass away and have the wealth that we've built up together to go to my business partner. What I would prefer is if I passed away, my spouse or my children would get my portion of the property, so we actually would own as tenants in common from a business perspective. Now, if you own property in joint tenancy and you begin to have problems with your spouse or significant other or life partner, depending on how you want to refer to them, you might want to check title to make sure or talk to a lawyer, because one person can sever the joint tenancy relationship without even telling the other, without the other's consent. Okay. All right. Next file, condominiums. In most of the provinces, we have a strata lot or a strata act, which allows condominiums. So in a condominium, you own your unit as a fee simple, but then the common property is owned in common, and you all pay something towards the upkeep of it. All right, so that's ownership of real property. Now, leasehold interests is renting or leasing commercial premises or renting a suite or something like that. So a leasehold estate is an interest in, but not ownership of, land for a definite period of time. So you go and you rent an apartment, and you pay the beginning of the first month, and you pay at the beginning of the next month, and you pay at the beginning of the next month. It doesn't sound very definite, does it? Well, at law it does, because you don't have a lease on property indefinitely. What you have is a lease that begins on the beginning of the month and ends at the end of the month. And then you have a new leasehold interest at the beginning of the next month and ends at the end of that month. So there's a whole series of definite periods. Or you can have a 12-month lease or a 6-month lease or a 5-year lease, okay? There are definite periods of time. We'll get into commercial tenancy a little bit later on, but the next, back up. At the bottom of that slide, we start interests less than estates, okay? So this isn't ownership, this is the right to use in some way. The first is an easement, which is the right enjoyed by one landowner over land of another and is obtained for a special purpose rather than for general use and occupation of the land. So my wife and I, before we moved up the Sunshine Coast, almost bought a property in Tsawwassen. And it was a nice house, a nice sized lot, and there was a swimming pool. And there was a cement patio around the swimming pool, and there was a pool house at the back. And as we were doing our investigation, we found we didn't find it. We actually got from the land title office a copy of title. And it mentioned there was an easement across the back of the property that was owned by the municipality of Tawasin. Yeah, or Delta, I guess it is. And we asked the real estate agent, and now there are good real estate agents and there are bad real estate agents, just like there's good lawyers and bad lawyers and good judges and bad judges and good doctors and bad judges. This real estate agent just lied to us, okay? She said, oh, that easement, yes, it's for the municipality, in case they ever had to enlarge the size of the sewer, which runs under your property and the property behind you. But, it'll never be used. It'll never be upgraded, so it's no problem at all. I looked, and it ran underneath the cement patio for the pool, and the pool house was on it. And if they ever had to dig it up, it would be too close to the pool, so we'd have to drain the pool. And just a mile down the way, there was a huge subdivision going in. And the sewer from the subdivision would run this way. And so I went, you know what, it's going to run right through this property, and maybe they're going to have to upgrade it, okay? So you have to check easements on title. The next slide is just a joke, a cartoon with respect to that. So these people bought the house without checking the easement, and they find out that the train tracks run right through the middle of the house. Okay, a bit of a joke, but it is a very serious matter to deal with easements. Right of way, the holder may pass back and forth over land to get to and from his land, which means if there's a road allowance, for property behind you that runs through your property, they have the right of way to go across that. You cannot stop them because they have to get from the road through this property to their property. Okay, that's like an easement as well. They're very similar. A right of way would be hydro wires. If there was a concern that if those big hydro wires from tower to tower went over your property, eventually the electrical current would cause you some health issues. Okay, the third type of interest less than an estate that you have to worry about is a covenant. Okay, a covenant, when someone sells property, they put a covenant on it sometimes. For example, I had a client who bought a lot in West Vancouver, and he was going to build a house. And there was a covenant on the property. And I asked him if he wanted me to go to the land title office and get a copy of the covenant. He said, no, it's no problem. He'd take care of it. Unfortunately, I told him in writing, all right. He got it, didn't really read it, didn't give it to his builder. His builder built the house. And the neighbor behind him said, you're 11 inches too high. You have to change the roof design. And he said, well, you can't tell me to do that. And he said, oh, yes, I can. There's a covenant on the property because I sold the property and I wanted to make sure that you didn't build your house so high that I would lose my view. And he was, of course, going to sue me until I pointed out that, he had paid me my legal fees, and in there it said that he would do that himself, and he didn't want me to do it. Okay, so that's another one of those CYA letters that you want to make sure you do constantly in business to make sure that there's a record of what goes on. It's called a paper trail. Anyway, that's a covenant. There are other covenants. For example, there's a lot in Seashell where someone's building a house, and he has a view of the water over the house across the street, and the covenant on the property says that that guy's house can plant trees, but he cannot let them go over the height of his eaves. All right, so those are the kinds of covenants. They're called restrictive covenants. They're covenants running with the land. Another really bizarre example, there was a condominium development in North Vancouver where there was a covenant that said that you could not plant daffodils, and that you could not plant anything else. Okay, so they wanted in spring daffodils everywhere. This person planted something else, and they got an injunction against him to not plant daffodils. Okay, it has to be framed in the negative. So they had to do two negatives to make it a positive statement. All right, so those are covenants. Interest less in estates, one more, and it's called profits a prendre. The right to take is what that means. It's French. And it has an English common law meaning. Profits a prendre means someone can come onto your property because they have the right to take the minerals out. This is the NDP in North Vancouver. All right, now we're talking about land and the ownership of it. The question becomes, how do transfers of land occur? And they can occur three ways, and this would make a really good exam question for Part B. The first, there's transfers by statute, transfers by will, and transfers by grant. Okay, on slide 15, we're going to talk about transfers by statute, so that's a statute law. If I own property, I had no heirs, and I haven't got a will, and I don't leave the property to anyone, what happens to the land when I die? No heirs means I have no relatives. Okay. Well, there's a cheat, which is a term which means the reversion of the land to the crown when the owner dies without a will or any heirs. And so we have an Escheat Act in BC that says if I die without a will saying where my land should go and I have no relatives, then it doesn't automatically, then the government can take it using the Escheat Act. The other way it can be transferred by statute is if I have heirs, but I die without a will, then somebody becomes the administrator of my estate, not the executor, the administrator. They have to apply to court, and it's really quite costly, but it's all done under the Wills, Estates, and Administration Act. And they would become appointed my administrator, and then the property gets divided up amongst my heirs in accordance with, my spouse would get it first, my kids would get it next, my mother and father, if they were still alive, would get it, and so on and so on and so on down until my dweeb of a nephew 12 times removed is the only person left, and he gets it. Okay. My nephew's actually a really nice guy. Just kidding. Okay. That's by statute. By will, you leave it in your will. Okay, but the will doesn't automatically transfer the property. You actually have to transfer it under the Wills, Estates, and Succession Act. But they have to transfer the property to the beneficiaries you've named. And then the third category is by grant. This is most common, okay? Eventually, my wife and I are going to sell this property and we're going to move into a house that we're building. Well, we grant title to somebody else, okay? And this is done by way of the Property Transfer Act, okay? And this cartoon it looks funny. It says, how much longer is it going to take to finish the lengthy title search, property search? Why the discovery of the New World took longer than expected. So obviously, whoever that explorer is has decided that he wants to claim this land in the name of the crown and some other continent, but he's just checking with his lawyer first. And as funny as that sounds, you should never buy land, without doing a title search. Okay. Okay. The next slide gets into commercial tenancy and risk management. And although there is no portion of the textbook that talks about property, land, and buildings, and I will provide you some updated material online for that, the Chapter 9 does have a section on commercial tenancy. Okay, so when you, I lecture on this, and then you want to be able to read that and sort of fill in the gaps or have things explained in a different way. There will, however, be a short break because there is another one of the meetings at CAPU that I have to go to via MS Teams, and so I will be back shortly, although on the video you will not notice the gap.